Judge LaSalle, thanks for being here today, and thank you for your service to the people of the state of New York. As you know, your nomination has faced quite a bit of scrutiny and questions, but that's part of the vetting process. So part of the state constitution says in order for you to advance to the next step, you have to come here, and we have to do our job of due diligence. It's a function of our democracy. I consider your nomination to be akin to someone nominated to United States Supreme Court. Being the chief judge of the Court of Appeals in New York State is a big deal, and it has profound implications on the law in the state going forward. And if you get confirmed, you will be on that bench probably for a very long time. So I want to thank you for the time you took to meet with me last week, to answer some questions. But the first thing I did when I heard about your nomination was to go read your cases. So I spent a lot of time over the last few weeks reading appellate division cases. I'm not going to hold that against you, but it is more appellate division cases I had to knuckle under since I was in law school. And it doesn't make for the most enjoyable reading. But I wanted to discuss in particular the Cablevision matter. You started this conversation with Senator Lanza, but the issue is this Martin Rule. And let's talk a little bit about this for the non-lawyers here. Martin Rule, it's an old doctrine, 7 years old, but it's sort of hard to understand. But the big takeaway is that unions and union members, they can't be sued for doing their jobs. The rule, as I said, 7 years old. It came apart. This decision happened when employers were trying to use state courts as an effort to chill unionization efforts. And you sort of think about the Martin Rule this way. Nurses in a hospital are in a dispute. Nurses picket, they protest, and they say the hospital's bad, they don't have the right staffing to serve people. But before the Martin Rule, those nurses could have been sued, saying you're damaging the reputation of the hospital. Now that would, of course, chill unionization efforts, but the court, through Martin, sort of got out of the business of being involved in unionization and workforce fights, and they pushed it all to the National Labor Relations Act, right? So if you have a dispute with your employer, employee, terms and conditions, you don't generally come to the state court. You go to the National Labor Relations Board. That's where you'd go to settle picket line disputes. But the Labor Board's cognizant of the fact that the state courts can be used as tools and weapons to chill unionization. So under the NLRB, an employer bringing a defamation suit in state court is a sign of an unfair labor practice, that you're trying to go around the board to use the court to chill the efforts. So the Martin Rule established that really union members involved in doing their union work can't be sued. Over 100 cases have been decided on that. In modern history, there was a Duane Martin case in 2005 where, big company in a scrap, with their union.
Was that Duane Martin or Duane Reed?
Duane Reed, sorry. I'm confusing my Duanes.
That was the first department case, correct?
It was the first department case in 2005, and they tried to come directly to state court to sue under a similar tort. And that court held that you can't sue union members for doing their job. This isn't the forum. Go somewhere else for that, back to the Labor Board. But 10 years after that, Cablevision came to the second department. And in Cablevision, union members, activists were handing out flyers, pamphlets. They set up a website, a petition, and they did teletown halls. Cablevision, big company, they responded by suing in state court, but not just the unions, but also the people who work for the unions in their individual capacity. And the second department, in my opinion, they didn't follow 70 years of precedent. They allowed the cases to continue against the individuals specifically said, we deem the Dwayne Reed case inconsistent with Martin, and we reject it. We decline to follow it. So it puts a twist on 70 years of precedent and seems to dismiss it. But in the same opinion, you implied that the union members are welcome to use Dwayne Reed and Martin as a defense. But that turns the Martin rule on its head. The Martin rule had traditionally been a shield protecting people involved in union activities. But the Cablevision case turned the Martin rule into a sword, where now the employer is able to use the state court defamation process as a sword to attack unionization efforts. In your opinion, you state, quote, the Martin rule is merely a potential defense to the allegation. But what does this mean in the real world? It means that the case then proceeds against the union folks in their individual capacity. So that puts a behemoth company, Cablevision, against a few union folks, on their own. Cablevision, I would have to note, employs a law firm that has 2,800 lawyers. And so the decision sets up a situation where we seem to be helping Goliath at the expense of David. Now, as I mentioned earlier, these cases are part of a multi-year, 70-year campaign to bring these disputes back into state court, where, of course, the large corporations will have a tremendous advantage. There's a similar case right now pending in front of the state court, the United States Supreme Court, which is troubling. So I have three questions, and I'll come back to them if you need be. But what did you find in this case to distinguish it from Dwayne Reed? How do you expect union organizers to do their job if at any moment they could be sued in their individual capacity and then have to cover all the costs out of their pocket? And then finally, looking at law as policy, how does this not have a chilling effect on all unionization efforts in New York State?
Thank you for the question, Senator. Let me state that the idea that management would use litigation to try to chill the First Amendment rights of association, of collective bargaining, of freedom of speech against union members is unacceptable.
But it is a common practice.
I don't know if it's a common practice. You may know that. I don't know that. All I know is that it's unacceptable. When you mentioned Dwayne Reed, however, my recollection of Dwayne Reed was they never got to the second cause of action, which dealt with whether or not the individuals were working in their individual capacity. That's my recollection of Dwayne Reed. It only dealt with the union members working in their capacity as labor union members. That's my recollection. So we do make a statement that to the extent that this deviates from Martin, we do not follow it. Because we did not come up, we, being the court that I sat on in that decision in 2015, did not come up with the prospect that individuals acting in their individual capacity could not be sued. The court in Martin did that. Again, their interpretation of General Association Law 16 said that individuals can be sued if they're not working in their capacity. Those are my words, of course. But that's what they said. I didn't say that. All we did was interpret what has been the law for 70 years. And when I say the law, has been the judicial decision-making. I'm unaware, and perhaps I'm wrong, of any statute that this body has passed that indicates that individuals cannot be sued in their capacity when they're working as labor union members. I'm unaware of any statute that says that. So I'm simply relying on the interpretation of the courts 70 years ago. And I don't think our decision went any farther than what was said 70 years ago.
I would say that it's a very narrow interpretation, because in Dwayne Reed, the court said there's just no evidence of working outside the scope. The very action being alleged in Cablevision was a town hall sponsored by the union. Like, that's what they're being sued for participating in a town hall. And then Dwayne Reed, they said, there's nothing in the pleadings to suggest that anything happened outside the scope that should be actionable. So in Dwayne Reed, they dismissed it But in this case, you said that's a matter of fact and that it can be held as a defense. But that means anytime there's a town hall and someone participates in it, I mean, because really the only thing that brings them in as individuals is the caption. There's no facts alleged in this verified complaint of any actions taken part by a union member that's not just a plain old union job.
Wasn't it said, I don't have it in front of me, wasn't that at paragraph 38 where that was discussed of the complaint? And I thought it was discussed and laid out that the allegation was that they were working, that they were taking part in this teletown hall, and at the time had been speaking in their individual capacity. And again, Senator, as you know, in a motion to dismiss, the court is required, whether it's this or a plaintiff's case of a personal injury or medical malpractice, we don't have a different standard, that the facts have to be assumed as accurate that are laid out in the complaint. So accordingly, again, let's also note, this was pre-discovery. There was no affidavits. There was no depositions. There were no interrogatories. There's simply the complaint and the answer. So again, the idea that my court had ripped a hole in the Martin Rule, I don't believe is accurate.
I don't think it ripped a hole. I think it set up a path to walk around it. And the distinguishing between Dwayne Reed and this matter is pretty clear that in Dwayne Reed, the case was dismissed. In the Cablevision case, you know, the union employees, if they wanted to, they were going to be now sued as individuals in court. But I see my time is coming to an end. Thank you very much, Judge.
Thank you, Senator.